Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. Once again, Jurisprudence class, question paper 2017, question number 16. So the very facts are, rigorous imprisonment was given to a disabled criminal. Yes, definitely. Criminal is a criminal, maybe disabled. Some people, some blind persons are also doing crimes. Some disabled persons are also committing crimes. Yes. So anyway, case is a case. Rigorous imprisonment was given to a disabled criminal, but no proper treatment was provided to him by the jail authorities. This is dangerous. Human rights problem. Appeal to the governor for tender of pardon. So since these people are not giving any treatment, no proper treatment is provided by the jail authorities, he filed an appeal to the governor for the tender of pardon. You may be knowing. So Article 161 of the Constitution of India. Right. Coming to this jurisprudence problem is a very good question regarding pleasure and plain theory. So constitutional provisions. You may be knowing. An arrested person, a convicted person has got all the rights except the right to movement. Now the issue is whether proper treatment should be given to the disabled criminal by the jail authorities or not. This is the issue. Okay, right. And now we'll start the discussion. Already I just started the discussion. You will be knowing that a criminal, no doubt, even though he is a convict, he has got all the human rights. So, right to treatment, it is there in section 53 of the CRPC and it is there in the Indian Constitution. Right to life and liberty, Article 21. Only thing is, he will have no right of movement as he pleases. He cannot move any place as he pleases, but he has to be there. So, this is the only option. This is it is a better question for the human rights. But anyway, since they have asked this in this particular jurisprudence, yes, definitely. What is this theory? Sociological theory. Man is a social animal. He should be protected, no doubt, even though he is a criminal, as long as his health is concerned. Actually, very classic case is there. I think he might have given basing on that mind only. I am telling you the case of Professor Sai Baba from Amlapuram, but he went to Delhi. He was a professor in Delhi. He is 90% disabled person. 90%. Always he will be. You can see him only with the wheelchair. In the wheelchair, that's all. He will not go out of the wheelchair. Even for passing urine or two stools, he has to be assisted by a person. But no doubt he was arrested in Gadchirowli case. Gadchirowli case for links with the Maoists. So Jain students like Hari Mishra and 4 others, they were actually molded by our GN Sai Baba to wage war against the government and supporting the Maoists. Anyway, he was arrested on in May 2014. I am not getting the date. He was arrested May 2014. Right? He was there in Nagpur jail. So he said, urination is difficult with a burning sensation. So whenever he gets urine, normally, as old people we know. So after 2 or 3 hours sitting is over, normally we have to go and piss off. Otherwise, our bladder will be full and we may be having the tendency because of the old age. And that too, he is a professor, always wheelchair bound person. Definitely in such cases, whenever he calls, so the protocol requires this officer has to inform somebody, that man has to come, they have to shift him. By the time he may pass urine in himself, or it will cause burning sensation. Very problematic. Very simple but problematic is the practical problem. And he wrote, my head is breaking, extreme pain in the abdomen. He complained of lack of minimum facilities and manhandling by the police escort people. Suppose, konchi pattern and ani or deba. So this is the tendency of the police as observed by the common people. So manhandling by the escort, and he narrowly escaped to fall from the wheelchair. ఒకసారి తనే వెళదామని ట్రై చేస్తే జారి పడిపోయాడు, లక్కీగా దొరికాడు, లేకపోతే వెళ్ళిపోయాడు. సో దిస్ ఇస్ ఆల్ ది ప్రాబ్లమ్స్ he faced. But case is very serious case. You can read the case law as GN Sai Baba versus State of Maharashtra 2019. So in this case, after so much time, since it's a very serious case, so he was booked under sections, convicted under sections 13, 18, 20, 38 and 39 of UPA Act, that is Unlawful Activities Prevention Act 1967. Of course, more than that, section 120 IPC was also there. It's very problematic. So therefore he was in jail, just like Varavar Rao. So only he is just bodily alive, that's all. Almost very bad case. Likewise, GN Sai Baba also was there. Luckily his wife fought teeth and ultimately he came out. So here the important point is, so suppose if you ask the Nagpur jail, what they say, yes, there is a medical officer, there is a resident medical officer, he is looking into it, but practically, so when I give the example of passing of urine, very, very difficult. So somebody should be there even to pass urine to him. No attendant was there. So definitely classic case of not proper treatment in the jail. And second case, this is Neera Ranjan Pillai versus Union of India 2011. Neera Ranjan Pillai. Actually, Neera Ranjan Pillai, she is a lady. Her father, Ranjan Pillai, he died in Tihar jail. So he was not given proper medical treatment. So actually, I think he was cheating. He was arrested in a cheating case from Dubai. I think he came by India. He was kept in Tihar jail. So the allegation is that since Tihar jail people did not render proper medical aid, he was hospitalized, and in the hospital itself he died. So due to the medical negligence of the doctor. But you know, he died on 7/7/1995. Right. So a committee was established. Medical, these people, Tihar jail people, they said that they have taken all precautions. Just like I told you, a resident medical officer there, they used to examine the patients. Ultimately, the court did not agree. They have appointed a medical council. The medical committee, they have disclosed that the death is due to medical negligence. Finish. So it is the duty of the jail authorities to take care of the person with a disability. They have to give him proper treatment. Since they failed, the Supreme Court ordered 1 lakh compensation at that time. This is in 2011. So likewise, so many incidents will be there. But anyway, to conclude, I want to tell you that basing on the above cited case laws, particularly the case of Naga Sai Baba, it is the duty of the prison authorities to give treatment, to render treatment. No doubt, definitely they will say that they have got a resident medical officer, or they have got a medical officer, or the local medical officer of the government hospital will come and examine them. They will be saying that. But in times of need, the medical officer should be there. So there are different occasions. So as a senior man, I know all these cases. ఎందుకంటే కొంతమంది కావాలని చెప్పి కడుపులో నొప్పి అని చెప్పి గిర్రం తిరిగి ఇన్ఫ్లుయెన్స్ కలవాడు హాస్పిటల్కి వెళ్ళడానికి ట్రై చేస్తాడు. ఏమీ లేనోడు నిజంగా వచ్చినోడు పడిపోతాడు. సో దీస్ టూ కండిషన్స్, ఎస్, అది తెలిసేది ఎవరికి ఓన్లీ జైలు అథారిటీ. కాబట్టి వాళ్ళు కేర్ఫుల్గా ఉండి ఏది నెససరీ, ఏది అన్నెసరీ, ఏది ఒరిజినల్, ఏది డూపు తెలుసుకుని చేయగలిగితే డెఫినెట్లీ ఇట్ విల్ బి హెల్ప్ఫుల్. ఎనీవే, it is the duty of the precursor. According to the prison manual also, the rules clearly say that if anybody complains of any pain, he has to be referred to the nearby hospital, or the resident medical doctor should come and examine him. This is the thumb rule. If they violate, definitely, just like our Neera Ranjan Pillai case, you will get compensation. Of course, this is a case of law of torts only. Here, please remember the judicial parties. Yes, human life is more valuable. No doubt he may be a criminal, he may be a convict, but rights are there. All rights will accrue to him except the right to movement. Okay, with this I am concluding. Thank you very much.